All rise. The Court of Appeals, Division 1 is now in session.
Thank you all. Please be seated. This is a time set for oral argument in our case number CV22-0388, Arizona Republican Party et al. Versus Katie Hobbs et al. Counsel, good morning. I apologize, first of all. You were moved from a different courtroom given a hiccup internally, and I hope that that has not caused undue strife as you prepare for oral argument this morning, but please accept our apologies for that oversight. Each side is allocated 20 minutes for argument. Appellant may reserve a portion of that time for rebuttal, of course, if you wish to do so. If you wish to do so, you need to keep track of your own time at the podium clock. Out of respect for counsel and to avoid any undue embarrassment, I would ask those in attendance to make sure your cell phones are off so our proceedings aren't interrupted. We've read the briefs, we've conferenced the case. This morning we're familiar with the record. We'd encourage you to keep that in mind during your presentation this morning. Proceedings are being recorded and will be posted to YouTube, so please, as you begin your argument, state your name and the party that you represent. With that, Mr. Culloden, you may proceed.
Thank you, Your Honor, and may it please the Court. I'm Alex Culloden, joined here today by my co-counsel, Ms. Lucero, and Mr. Dershowitz via telephonic on behalf of appellants. I wish to make a few brief points, then reserve at least 10 minutes for rebuttal.
Can I throw you off from the start?
Certainly, Your Honor.
I think we just had some questions. There seemed to be some differences in the approach that you guys took in the opening brief versus the reply brief, and so I just want to make sure that we're all starting from the same page. Is the preliminary injunction request moot?
I believe so, Your Honor. The election has passed.
Okay. Are you conceding that mail-in voting is constitutional as long as, and I don't want to get into the specifics of it, but if there's secrecy in voting, whatever that is, it's constitutional to do mail-in balloting?
Your Honor, we're not challenging mail-in voting overall. What we're challenging is the current system of mail-in voting where a restricted zone is not secured around the voter.
And then, is the challenge to the mail-in voting solely a facial challenge?
Yes, Your Honor. I think that's fair to say.
Okay. And so, lastly, and I think you've answered this, but are you conceding that the Constitution does not require in-person voting?
Your Honor, what we are conceding is that mail-in voting is not clearly unconstitutional, which is the standard. It does appear quite likely, actually, that it's constitutionally required, but in light of Burson, it's hard to say that it's clearly unconstitutional because there could be ways of conducting it as we did prior to 1991, where a restricted zone is still secured by a public official.
Okay, thank you.
So the first point I wish to make is that if all preserving secrecy means is that the misconduct that the framers were concerned about was to be prohibited, then we lose this case. But the requirement that such misconduct is to be made illegal is already covered under a separate portion of the Arizona Constitution, Article 7, Section 12, which requires the legislature to enact laws to secure the purity of elections and guard against abuses of the elected franchise. And it was precisely because such laws alone had proved insufficient during the Gilded Age and the territorial days to prevent the political machines and corporate interests that the framers were concerned about from engaging in vote buying and coercion and undermining faith in the democratic process that the secrecy requirement was added to the Arizona Constitution. And they were wise to do so, for as the U.S. Supreme Court has recognized, it is virtually impossible to detect vote buying and coercion after the fact. Instead, as the trial court correctly held, Article 7, Section 1 mandates the use of the Australian ballot, a process by which votes are cast under the supervision of public officials. Securing a protected zone around the voter while they are voting is the only way to actually preserve secrecy. Traditionally, this was effectuated by requiring voters to vote at the polls. In the 1920s, the Arizona legislature came up with a creative way to extend these same protections to absent voters. In 1991, the legislature unconstitutionally dispensed with them. The requirement of secrecy is not waivable. If it were waivable, voters who are interested in selling their votes could waive it, because vote buying and selling is always a voluntary transaction. And similarly, those who wish to coerce voters to vote a certain way could also coerce those same voters to waive secrecy. Instead, the Constitution's provisions are mandatory on both the governed and the governing.
And other than adopting an Australian ballot system, is there any other historical record that you have found that tells us what secrecy in voting meant when the Constitution was adopted?
Certainly, Your Honor. So the same year that the first version of the Arizona Constitution that did not contain the secrecy in voting requirement was propounded, the legislature also passed a law conveniently titled, and I'm paraphrasing, but close enough, an act to secure secrecy in voting and preserve the purity of elections, et cetera, et cetera. And in this act, it's the Australian ballot system on all fours. It is voting at the polls with an elections official, excluding other people who are not voting from the polls, preventing other people from looking over the voter's shoulder or having access and being able to see how a voter could vote. And it's quite clear that that's what the legislature meant. And indeed, the source from Leahy that we cited indicates that it was this conception of secrecy in voting that the framers were intending to incorporate into the Arizona Constitution when they added the words, provided secrecy in voting is preserved.
How are we instructed by, if at all, how ballots are cast in Australia today?
How they're cast in Australia today?
Is that instructive? You've mentioned the Australian ballot system adopted that you submit in the 1912 Constitution. Should we look to Australia to see what they're doing now to see if it's consistent?
I'm not sure whether Australia today uses what's known as the Australian ballot system, and I don't think that would have any relevance or instructive force for the court. The Australian ballot system was the process pioneered by Australia at the time or shortly before the time of the framing that was adopted in U.S. states. Whether their current system conforms to that, I couldn't say.
So your position is then that regardless of what has happened in Australia in the last 110 years, that's irrelevant?
I would say so, Your Honor.
Okay.
Yeah, this is a question of Arizona constitutional law and the intent of the framers of the Arizona Constitution. Obviously, they couldn't have known what would happen in Australia over the next 110
Counsel,
years.
we often take the provisions of the Arizona Constitution, for example, ones drafted in Washington, and see what Washington did with it. Why wouldn't we do the same with Australia? I mean, if you say that this came from Australia, why wouldn't we look at that and understand what Australia meant back in 1912?
Well, I don't believe Australia made the Australian ballot system, and Your Honor, you'll have to forgive me, I'm not incredibly familiar with Australian law, but I don't believe it was a constitutional law provision that they had added. I think it's something that they adopted by statute. Again, I'm not
But
positive.
even so, we look to them to see what they meant.
Well,
We're looking to them to adopt their way of doing things. I'm a little puzzled by that.
Well, if they subsequently changed the law after the framing, that would not have any impact on what the framers could have meant.
What if they didn't subsequently change the law but allow now mail-in balloting? Is that instructive?
I don't think anything that happened after the Arizona Constitution was ratified is instructive to the framers' intent. And again, if your honors would like supplemental briefing on what happened in Australia and for us to research that, we're happy to submit such briefing to the court.
Better understand your argument, counsel.
Let me go to, I'm sorry, I didn't mean to
No,
stop.
that's fine.
Let me go to the exact language of the Arizona Constitution you're arguing. It says it's to guard against the abuses of elective franchise, and the legislature was charged with enacting those. How is it that we don't just accept, how do we look around what the legislature did to say that they didn't guard against the abuses with this provision in 1990.
So, Your Honor, this is exactly my point. That's a separate section of the Arizona Constitution from the one our case is principally based on. If Article 7, Section 1 is also to be interpreted simply as requiring the legislature to enact laws to secure against abuses of the elected franchise, then those are duplicative sections, and one is rendered meaningless by the inclusion of the other. Clearly, they have to mean different things and supply different instruction and prohibitions on the legislature.
Let me tease that out. Section 1 says, the secrecy of voting shall be preserved, right? That's your section.
Yeah, more or less.
More or less. I think that's the section on which you say your case is founded. That's where you build your house.
Yes.
Okay.
Just the exact wording is slightly different, but yes.
No, provided the secrecy in voting shall be preserved. That's
Yes.
the exact quote.
That is
That's
correct,
what
Your
I
Honor.
read. Now, in doing that, the Constitution goes on in Section 12 and says how we're going to do that. And it says the legislature is the one responsible for it.
I don't think that's an accurate reading of Section 12 with Section 1. Section 12 talks about enacting laws to guard against abuses of the elected franchise,
Which
right?
might be, and I think reasonably is, allowing and not protecting the secrecy of the ballot. How is that not subsumed in that?
Because, Your Honor, when the framers enacted Article 7, Section 1, they had something very specific in mind, not simply general laws prohibiting vote buying, prohibiting coercion, right? Those laws existed during the Gilded Age, and certainly by including the provision that you mentioned, they certainly intended that those laws would continue to exist. But it was because these laws on their own proved insufficient during the Gilded Age and the territorial days that the additional requirement of preserving secrecy of
Where do I
voting.
find any of that in the Constitution? Where do I find that textually? They were worried about this, they were worried about that, this is how we should read it. Is it in there?
So, Your Honor, in Burson versus Friedman, the U.S. Supreme Court explored the history of the Australian ballot system and what the concern were of the people who had implemented it across the country and why they had done so. And it's in that exposition that you will find the reasoning that I've just elucidated. That would be in Burson versus Friedman.
Okay, and so secrecy was important, and then they said to avoid abuses, which I think would you concede that an abuse would be not providing secrecy of the ballot? Or do you say that's not an abuse?
Well, what secrecy of the ballot does is not merely prohibits the abuses, right? It prevents the abuses a priori. It stops them from ever happening, and it avoids even the appearance of impropriety in the election system. So it's something slightly different, not just punishing.
What does the legislature have to do? I mean, what you're arguing is you just don't think the legislature went far enough in the secrecy. That's all it is. You're asking us to second guess how far the legislature went.
I don't think, well, I would agree with that, not with respect to purity, right? I would agree that the current laws guard against abuses of the elected's franchise and help to secure the purity of elections, more or
And at
less.
least provide some level of secrecy. The voter has to seal it, mail it. It's not, the elections officials don't know who cast that ballot when it's actually run through the machine.
So I think this is the crux of the case, actually, is as Your Honor is elucidating, there are two potential arguments here, right? One argument is that secrecy is subject to a qualitative analysis, as you've just expounded, right? If it's subject to a qualitative analysis, then it's within broad discretion of the legislature, certainly, right? But if it had a fixed and definite meaning at the time of the framing, then it is not. And what we are arguing is secrecy was not a sort of results-oriented thing. It wasn't, have the abuses been secured against? Secrecy, because the framers understood that it's really hard to tell if this sort of malfeasance is going on. Secrecy is an a priori prevention of these abuses happening, right? Secrecy in voting requires the zone to be secured around the voter while they're voting so that such abuses are simply impossible to occur and that they don't have to be detected after the fact, right? This is borne out by the constitutional history and the framework of the Australian ballot system.
Well, counsel, let me ask you this, because it seems to me your argument then is that we can't even have someone assist a voter, because that would breach the confidentiality, and yet we have provisions specifically designed to help a voter who needs help. And that involves a second person providing the assistance, whether it's a family member or even somebody who's a member of the polling board. So are you saying that this has to be done, a voter has to mark their own ballot in absolute secrecy, has to occur, so in effect, you would extend your argument all the way to not allowing assistance for any voter?
So,
It seems to me that's the logical extension of your argument.
I'm glad you brought up that point, Your Honor, and I break it into a couple different points, right? One is what you mean by assisting a voter. If what you mean by assisting a voter is anything other than actually helping them fill out their ballot, right? If it's before they fill out...
You can't have someone stand near you when you're at home in your own kitchen, and that's violating secrecy in voting. Why doesn't the same apply to Judge Goss's scenario where someone is within their zone? How are we to know what they're doing? They're assisting, but you're saying the zone can't be violated or else the Constitution is violated. So help me understand why my kitchen is different from a place with walls up, but someone standing in the booth with me.
Certainly, Your Honor. I think you're asking the same question. So I just want to just make clear what I'm talking about. I'm talking about assistance before the voter has filled out their ballot, assistance after they've sealed their ballot or deposited it. Any of those assistance wouldn't be implicated by our argument. To your point about assisting voters while they're actually filling out the ballots, indeed, the Arizona Supreme Court addressed such a case very shortly after statehood, and they held that such assistance did violate the secrecy in voting provision, right? That it did implicate a violation of the Australian ballot system. It was entirely consistent with your logic. Now, obviously, subsequently, we have case law out of Arizona's courts and the U.S. Supreme Court about equal protection. I wouldn't deign to argue that in perfect adherence to the Arizona Supreme Court's early territorial decision would be in conformity with the Equal Protection Clause when you're dealing with a disabled voter, things like that. I don't think that it is a necessary extension of our argument in this exceptional case where another constitutional provision is clearly implicated to say that the general prohibition on having assistance or anybody...
So it's okay to violate this pristine, absolute guarantee of secrecy sometime?
I wouldn't go that far. I would simply say that's a possibility. That's not presented by the case at bar, right? It's not preserved in the record or argued whether this sort of exceptional case of violation...
Would you agree it's a natural extension of your argument?
As did the Arizona Supreme Court. Yes, I would.
Can you also talk about the 1918 Soldiers Voting Act and how I understand the tension between two constitutional concepts there, that when they played up against each other, we say Soldier Voting Right Act is okay in the secrecy realm that we're talking about here, but why then isn't it okay for any other citizen of Arizona just because of the employment circumstance of a soldier? If it's okay for them to do it that way, why isn't there some sort of equal protection argument that, well, the soldiers get to do it, and I should get to do it?
So that requires reference to the free and equal clause and what this court actually said about what it requires in Yazzie versus Brewer, which is other states with similar constitutional provisions have generally interpreted a free and equal election as one in which the voter is not prevented from casting a ballot by, and I'll just go to the relevant section, intimidation or threat of violence or any other influence that deter the voter from exercising free will. If you actually look at the text of that constitutional provision, it specifically talks about powers, civil or military, preventing a person from casting a ballot. And obviously, if you're a soldier subject to deployment at any time or deployed overseas, that is on all fours a power military preventing you from casting a ballot if the if you're required to cast it in person, or if you're required to have an Arizona public official there when you're casting it, because obviously there can't be a public official on the
Practically
battlefield.
speaking, we're allowing a soldier not to have privacy in voting. Why can't we extend that to any other citizen if it's okay under just the secrecy provision of the Constitution to do it that way? Why isn't it okay for other people to be able to implement that as well?
Two reasons. First of all, with a normal citizen who's not in the military, there is no civil or military power actually wholesale
Understood.
preventing. Yeah.
I just mean that practically speaking, we're not requiring secrecy for that soldier, right?
Well, that's actually not true. If you look at the text of the 1918 Soldiers Voting Act, it's very clear.
We have.
Oh, okay. Your Honor, thank you. It's very clear that the drafters of that bill were trying to reconcile these two constitutional provisions, and they tried to hew as closely as they possibly could to the way that elections were conducted at the polls. I mean, it even said, essentially, if you're a soldier and you're filling out your ballot, you have to leave the trenches. You have, because remember, this was World War I era, and so that you can vote without anybody seeing your ballot. This is how seriously they took it.
And so again, I come back, I'm sorry.
Oh, no, I was just asking if you wanted to reserve his 40 seconds, but I
Well,
didn't
just,
interrupt you.
so I come back then to your only issue is you think the legislature didn't go far enough in protecting the secrecy. That's the crux of your argument. They should have done something more.
No, the crux of my argument is that the minute...
If it's okay to do it for the military, as long as you do it that way, but you don't like the way it is now, it's either that way or somewhere in the middle, right? But it's okay to have the mail-in voting.
So the reason that it's okay with the military is because one constitutional provision is going to get violated either way. And in that case, the legislature is permitted to balance. In a case where another constitutional provision isn't going to be violated on all fours either way, then the balancing is not permitted, and it far enough implies some sort of qualitative analysis. What I'm saying is the legislature violated the secrecy and voting provision when they didn't meet its minimum requirement, which is a restricted zone secured around the voter by a public official. They have broad discretion as to how exactly they're going to effectuate that. If you wanted to have mail-in voting with an elections official monitoring that room via webcam to make sure nobody could see how the voter was going to vote, that may perhaps be a permissible way of securing secrecy and voting by securing a restricted zone around the voter. The legislature can do it in any number of ways. What we're not asking this court to do is legislate. What we are asking this court to do is say what the law is and say what the framers intended by the secrecy and voting provision. The other side has not done so, and we have articulated what that means.
Mr. Cullinan, thank you. Your time has expired. Time goes fast. We'll give you a couple minutes for rebuttal, just for planning purposes, but thank you.
Thank you, Your Honor.
Thank you. So let me look to Appellees. How are we going to divide our time, gentlemen?
Your Honor, Andy Gaona, on behalf of Secretary Hobbs, the appellees have conferred. My intent is to take 15 minutes and to give at least 5 minutes to Mr. Ariano, who will be arguing on behalf of the interveners. Mr. Branco from Maricopa County is also here to the extent the court has any questions that are very county specific, but he does not intend to speak otherwise.
Very well, thank you. You'll need to keep track of your own time. You may proceed.
Thank you, and good morning, Your Honors. May it please the court. Arizona's current system of mail-in voting is voting by ballot and preserves secrecy because it exists alongside a comprehensive statutory scheme of safeguards and criminal penalties.
Mr. Guyana, I'm going to interrupt you like I did, just so we can make sure we're on the same page before you go too much further. Can you tell us, do Purcell and latches still apply now that the general election is completed and certified?
Your Honor, I would agree that at this point in time, the Purcell principle would not apply, though we do believe that the trial court erred by holding that the Purcell principle does not apply in state court. We believe that is an important principle that should apply equally in federal and state courts. I would say, however, that latches does apply. The fact of the matter is that the appellants here waited 30 years to bring this claim and then only brought it on the eve of 2 statewide elections. And under those circumstances, when this apparent constitutional violation has been, should have been noticed by the appellants, and in fact,
But what is the
violations of
prejudice
it.
at this point, now that we've come and gone from that election? I understand that there was more of an argument in June when you made it than there would be today, but what's the prejudice to your clients in going forward now with no general election on the horizon?
I agree, Your Honor, that the prejudice analysis is different in the sense that we're not on the eve of an election anymore. But the problem, and one of the problems that the Latches doctrine seeks to remedy, is a party that sits on its rights for here more than 30 years, and you have a whole group of Arizonans who develop a reliance on that interest. I do believe this court can and actually should resolve this case on the merits. To be clear about our position on this. This issue needs to be resolved once and for all so that Arizonans have clarity and can continue to rely on the safe and convenient methods of voting that the overwhelming majority of them have relied on now for more than 30 years.
What's your best case, pardon me, on Latches for the thought that delay in effectuating a constitutional challenge should be barred as a matter of equity under Latches?
Your Honor, I'm not sure off the top of my head that I have a great case that I can identify on that exact point. And as I said, I do agree that the Latches analysis for the court right now differs greatly. And in fact, the Secretary would prefer the court to reach this issue on the merits today. So I don't have a good answer for you as I stand here now. The fact of the matter is that the appellant's claim was properly dismissed by the trial court as a matter of law, though the preliminary injunction could have and should have been denied on Latches and Purcell principles to begin with, the preliminary injunction now being moot, as the appellants now concede.
And Judge Bailey, I interrupted.
Oh, no,
you.
I was just, my last kind of before question is, why is the allegation that the plaintiffs have to hold their primary elections in an unconstitutional matter insufficient to confer standing in a case like this?
Your Honor, because, well, first of all, Your Honor, I think that the nature of the grievance they allege is generalized to everybody, not just to the Arizona Republican Party. The Arizona Republican Party can conduct its affairs however it wants. In fact, sometimes the Arizona Republican Party cancels its presidential preference election, for example.
But if they hold them, they have
Yes,
to
I would
comply
agree
with
with
the
that, Your Honor.
Constitution.
I would agree with that,
And
Your
if
Honor.
we're assuming that they want to hold one, we're going to assume that they want to comply with the Constitution. Why isn't that standing?
Your Honor, again, this goes back to the Sears versus Hull analysis in the sense that it's unconstitutional as to, their concern rather as to unconstitutionality is a generalized grievance that would apply to any Arizona voter, irrespective of what party you belong to or whether you belong to a party at all. And in those circumstances, the Arizona Supreme Court has said that that is insufficient to confer standing.
Thank you.
What we've heard, as the court rightly recognized, and as developed further today, the appellant's argument has been a bit of a moving target. It's been hard to pin down. And where the court is left now is that the appellants are asking this court to adopt a construction of Article 7, Section 1 that goes far beyond its text. As I now understand appellant's argument, Article 7, Section 1, which currently says all elections by the people shall be by ballot or by such other method as may be prescribed by law, provided that secrecy in voting shall be preserved, actually continues by including a comma after the word preserved, and says by requiring that all citizens, except for service members and those requiring certain types of assistance at the polls, cast their ballots in a restricted zone supervised by a public official at a polling place. As far as I can tell, that is what the appellants believe that Section 1 actually says. It plainly does not say that. And in order to reach that result, this court would have to run roughshod over more than a century of jurisprudence in Arizona in terms of how we interpret the Constitution.
So, Mr. Gayon, I'm just going to jump in with Section 1 again. When we look at the text, it says all elections shall be provided by ballot or by such other method as may be provided by law. In other words, the legislature in the Constitution was given the ability to look at how it handles elections. It doesn't actually mandate the ballot. It just says either that way or as the legislature mandates. And then it says that the secrecy shall be preserved. Doesn't it also given that the way it's worded, give that discretion to the legislature to decide how to provide for that secrecy?
It does, Your Honor. Section 1 does give the legislature a great deal of discretion, and the legislature has exercise that discretion appropriately here. As I mentioned before, by enacting a comprehensive set of statutes that safeguard not only the process of actually printing and providing a mail-in ballot to a voter, but how that voter is supposed to actually vote the ballot, return it, and then how elections officials are supposed to handle that ballot.
And what's your answer to their argument that saying something, prohibiting someone from doing something and assuring that they won't do it are things that we should find carry the day in their argument, that that's not enough? Prohibiting or laying down laws that have penalties to them if you violate them is different from the prevention that they say has to happen in voting, which is to secure an area for them before they even vote.
Your Honor, my response to that argument is that that's how governments work. That's how statutes work. When governments want to regulate behavior, and in particular here where there's a constitutional command to preserve secrecy, and the legislature does have a great deal of discretion how to do that, the way that we regulate behavior and preserve secrecy is by enacting statutes that protect it, not only on the front end by prescribing how the process is supposed to be carried out, but also on the back end, by criminalizing the violations of that process that the appellants are concerned about. And I would point the court to page 15 of the appellant's reply brief, where they finally concede, I think, that their argument, their challenge rather, which is a facial challenge, is really based on the idea that in theory, there might be ways in which a voter who chooses to vote by mail-in ballot is coerced in their process of exercising the franchise rather, in a way that would violate the secrecy of their ballot. The problem is that the examples they identify, the legislature has already thought of them. They're criminalized. If a person is being coerced by an abusive spouse or is being threatened by their employer, then I would point the appellants to ARS 16-1012 and 16-1013, in which that precise behavior is subject to criminal sanction. And if the appellants have evidence that such coercion is happening, they should report it to law enforcement authorities. Instead, what they've done is launched a facial challenge adducing no evidence whatsoever that a single voter has been coerced in a way that violates the secrecy of their ballot, and certainly no evidence from the appellants themselves, and are asking this court to declare this system unconstitutional. That is simply not how facial challenges to statutes work.
Counsel, let me ask you, Section 1, one way to look at it is it addresses three things: voting by ballot, by such other method as may be prescribed by law, and whatever happens, secrecy needs to be preserved. You've indicated that the legislature has some substantial discretion in determining what those alternative measures may be. But Section 1 has to put some boundaries on what the legislature could do. Wouldn't you agree?
Your Honor, I would agree that there are some baseline boundaries. If the legislature prescribed a system for voting where if I were to cast a mail-in ballot, my name and address would be broadcast on the local news along with how I voted, I think the Secretary would be here, and I personally would be here saying that would violate secrecy.
Or a straw poll where you move to the kitchen if you're in favor of one candidate and the living room in favor of another. That's another example, perhaps.
I think that could be another example, Your Honor, but that is emphatically not the situation with Arizona's regime of mail-in voting that has existed since 1991.
And I understand that position, but it does seem to me that Article 7, Section 1 does put some limits on what the legislature could do. And if that's the case, the question is what they've done consistent with those limits?
Your Honor, I do believe that is the question, and I believe that the system that currently exists protects secrecy to the extent that it can. And to impose these additional burdens and to add additional words into the Constitution to reach the result that the appellants urge is not the way to do this. What we've heard, and to one of Judge Goss's questions to Mr. Colladin, is that their position is the legislature, based on the appellant's policy preferences, has not gone far enough. And it's a policy argument to be made. And the appellants can make that in the public sphere. They can make it to the legislature. I'm sure Mr. Colladin will be making it, and the new role he'll assume here come January 3rd when he becomes the vice chair of the Municipal Oversight and Elections Committee in the House of Representatives. If this is the way that the appellants want to sell this as a matter of policy, there are ways to do it. But the way to do it is to not have this court effectively rewrite the Constitution to limit the people's exercise of their right to vote. And that's exactly what adopting the appellant's view of this constitutional provision would do.
So let me try and identify maybe a bright line. With the provided that secrecy in voting shall be preserved. If the legislature were to enact something that in some way mandated that a public disclosure of a vote be required, that would violate that provision. No question, correct?
I agree, Your Honor.
And so then on the other side of that bright line, if the legislature has a great deal of discretion from my perspective, and I think yours, in deciding where in providing that protection, the legislature draws the line and says, we're not requiring you to publicly announce your vote, but how we do it beyond that is we're going to make that decision. Would that be a fair assessment?
I think that's right, Your Honor.
And let me ask you this, and just very quickly, because I know you've got time constraints, but with regard to a voter who wants assistance, does Arizona law put any restrictions on when a voter can ask for assistance? Do they need to make any showing? Or is it just a voter says, I'd like someone else in the booth with me, or someone at home, and then that person, if they do a mail-in ballot, has to sign that they've provided the assistance?
Your Honor, I believe that outlines the scheme. If a voter walks into a polling place, for example, and says, I need assistance filling out my ballot, it's a lot like, federal law as it relates to the ADA. The question is not why, it's how can I help you? And that's how it should be. We should be encouraging people who need assistance to ask for it and to get it. And Article 7, Section 1 simply should not be a bar to that person walking in. Take, for example, a person who can't hold a pen steady and needs a poll worker, a family member, a friend to go to the polling place with them in order to actually mark their ballot. If I'm the person providing the assistance, I'm going to know how they voted. But if I'm a voter, I have no other choice but to do that unless if I could use one of the accessible voting machines that most counties do have. But if they wanted to actually mark their choices on paper, as is their right, then they should have that right, and the secrecy provision should not interfere with their exercise of that right. Judge Goss, to get to your question, and then I'll sit down, I think, and allow Mr. Ariano to speak briefly. A lot of these questions get around to the fact that this is a facial challenge. The burden on appellants was to show that there are no circumstances under which Arizona's current system of mail-in voting could operate constitutionally to preserve the secrecy of the ballots cast by citizens who do so. The appellants did not and cannot carry that burden, and this court should affirm the judgment below. Thank you.
Thank you, Mr. Giona. Mr. Ariano.
Good morning, Your Honors. Daniel Ariano for the intervener defendants. Your Honors, I think it bears emphasizing that plaintiffs have abandoned the argument that the Arizona Constitution requires all voting to occur in person at a polling place on Election Day. I think you heard that today in response to Judge Bailey's questions. I think you see it in the reply brief at page 31, where they say that there's no meaningful distinction between voting in person and voting elsewhere, so long as it's in the presence of a government official or a notary. They say it again at page 43, where they say that their argument is about secrecy of mail-in voting and that it's not whether the Constitution requires in-person voting only. So I think on the merits now, this case turns solely on the question of secrecy in voting under Article 7, Section 1. And I think if the court were to reach that question, I think it can resolve it both easily and succinctly based on application of first principles. I think the first of those is that the legislature has the power to enact any law not clearly prohibited by the text or structure of the Constitution. And the second is that the court presumes the constitutionality of statutes and must construe them consistent with validity, if at all possible. Now, I think what that means here is that the court doesn't need to go looking or digging through law review articles or territorial legislation or irrelevant First Amendment cases to find some hidden meaning that's not readily apparent from the text or structure of the Arizona Constitution itself. In other words, the framers are not in the business of hiding Easter eggs in our governing charter. Yet I think that's precisely what these plaintiffs asked this court to do. They asked that this court to hold that secrecy in voting can mean only voting in the presence of a government official or notary and nothing else. Yet that exceedingly specific definition finds no support in the plain meaning of the term. It finds no support in the 1891 legislation that's been discussed. It finds no support in Burson or anywhere else.
So I think as to the narrow question that's left of the merits, I think that can be easily resolved, and I think it's as simple as that there's no support for the reading that they urge. Now, of course, we would urge that the court actually doesn't need to reach the merits, primarily because these plaintiffs lack standing. No plaintiff in this case has alleged or argued that they have been unable to vote in secret, that they will be unable to vote in secret in the future, or that they are harmed in any concrete way by the practice of early voting in Arizona. And I think I also want to point out that there's no statutory basis for standing either. As plaintiffs have argued in their reply, the declaratory judgment statute still requires that the plaintiff's rights or status be affected by the statute they challenge. And the Arizona Supreme Court made clear earlier this year in the School Boards Association case that simply having an interest in an issue is not enough to confer standing, or else that would eviscerate the standing requirement entirely. I think it's also important to point out that this is not a mandamus case, and so you don't get the benefit of beneficial interest standing either. There's no request here to compel any public official to perform any act. This is simply a facial challenge to the constitutional validity of a statute, and not a request that any person be required to do a specific thing as the mandamus statutes require. Finally, as Mr. Guyana mentioned, an interest simply in how primaries are run, we would agree is plainly and precisely the kind of generalized interest that both the U.S. and Arizona Supreme Courts have held clearly does not constitute an injury that confers standing. So for any and all of these reasons, we would urge the court to hold that plaintiffs lack standing to bring this suit and that their case plainly fails on the merits, and to affirm the judgment of the Superior Court. And if the court has no questions for me, I'm happy to cede the remainder of my time.
Thank you, counsel.
Thank you.
Mr. Colladin, rebuttal.
Thank you, Your Honor. A couple rapid-fire points. First of all, we never argued before the trial court that the Arizona Constitution requires all voting to occur at the polls on Election Day. That's an argument that we advanced in the original special action at the Supreme Court, which we later refined in this action. The second point is that, as Your Honor has noted, secrecy is an express restriction on legislative authority. What is being restricted? Well, there are many cases from the applicable time period that say, one of the ones we've cited, Sulzer, in our briefing says, it is idle to say that the Australian ballot system's essential terms are not mandatory, but are only directory. The official ballot and the secret booth are the very essence of the system. The legislature has, and they went on to say, they are the things that make the remedy truly a remedy. Without them, the evil sought to be remedied is not remedied. So without having a restricted zone secured around the voter, you don't get to what the framers of the Arizona Constitution wanted. Obviously, the Arizona Republican Party has an actual or real interest in the subject matter. Its rights status or legal relations are impacted, namely that it can't run its party primaries according to the secret ballot principles of the Arizona Constitution. It's not like a general grievance of other voters. It's a party that conducts party primaries under these laws. And finally, the assistance argument is actually a public policy argument. It's talking about what's desirable or undesirable, and it may be, as I pointed out, that is required by other portions of the Constitution. We take no position on that because it's not before the court. But there is, perhaps they think that the framers' views are antiquated, there should be change, and the good news is the voters have a very easy way to do that. They can amend the Constitution. The framers made it very easy to do. But unless or until that provision is amended, it is the law, and its essential requirements are the secret booth.
Thank you. Thank you, counsel.
Thank you.
Counsel, we appreciate your briefing. We appreciate your oral argument this morning. We will take the matter under advisement. We'll issue a written ruling in due course. Court stands in recess while we set up the courtroom for our next oral argument. Thank you.